Yeah. So welcome back, sir. In the last class, we were discussing about the consideration chapter. So we'll revise consideration and we'll do the scanner. What is consideration? Beta, it is defined by section 2D. For definition exam में पूछते beta. Definition of consideration: star, star, superstar, star, star, mega star. Keep 5 stars. Star, star, 5 star. Define consideration and its essentials. This will be question in the exam. What do you understand by consideration? Definition likhna beta. So what is consideration? Consideration means when at the desire of the promiser, at the desire of the promiser, promisee or any other person. So I made a promise to Ishwar. Ishwar, I will teach you CA foundation law. I am the promiser. I need 10,000 rupees. So what is my desire? 10,000 rupees. When at the desire of the promiser, promisee or any other person. So who is giving me 10,000 rupees? Ishwar, promisee, or any other person. Promisee's father or mother, Ishwar, or Ishwar father, or Ishwar mother, or Ishwar girlfriend. Can give the money. Consideration may be past, done, present, does, promises to do, future, or abstain from doing. It can be positive, it can be negative. If you come to class tomorrow, I'll give 500, positive. If it does not come to class tomorrow, I'll give 1000, negative. So consideration must be given at the desire of the promiser. It may be given from the promisee or any other person. It may be past, present, or future. It can be done or abstained from doing, positive or negative, and does or abstains from doing. Present activity may be positive or negative. Future activity may be present, positive or the negative. So done or abstain, past can be positive, negative. Does or abstains from doing, present can be positive or negative. If you come to class tomorrow, positive. If it does not come to class tomorrow, negative. Promises to do or abstain from doing something, such activity or abstinence, that positive activity or negative activity is called as the consideration for the promise. Bolo beta. When at the desire of the promiser, promisee, or any other person, done or abstain from doing, does or abstains from doing, promises to do, or abstain from doing something, such activity or abstinence, a promise is called as consideration for the promise. So consideration means quid pro quo, something in return. It can be in the form of the goods, money, or the service. So there was a case law, there was a case law, that is the Curry versus Misa, given by Justice Lush. So in this case law, Judge Uncle divided consideration into 3 parts. Benefit to both the parties. It can be detrimental to both the parties. Detrimental means opposite to benefit, compromise, loss kind of thing, negative thing. So it can be benefit to both the parties. I am teaching, I am getting money, you are getting knowledge. It can be benefit to one party, detrimental to other party. It can be detrimental to both also. Your compromise is my consideration, my compromise is your consideration. We both are compromising. Then so next one, essentials of consideration, very important from exam point of view. So first one, it must be given at the desire of the promiser. If you are doing the activity voluntarily without my request, you cannot get consideration from me. If you are doing any activity at the request of third party, you cannot get consideration from me. If you are doing something at my request, promiser request, then you are eligible to get the consideration. Then beta, yes sir, no sir, clear na? So if you are giving the pen voluntarily, you cannot get the consideration. If you are giving the pen to someone because of third party request, then you can't ask from me. I said, if you give me pen, I'll give 10 rupees. I am the promiser. So can you get the consideration? So we have discussed the case law also. So one boy is lost. His father found him in the main road. So if someone does the activity voluntarily, you can't get consideration. If you're doing the activity at the request of third party, you can't get consideration. If you're doing the activity at the request of the promiser, you're eligible to get them. Then next, it may move from any person. Very important beta. Chinnaya versus Ramaya. So I'm teaching to Kavya. Consideration may be given by Kavya only, or Kavya father, or Kavya mother, or Kavya husband also. Then beta, it can move from the Kavya itself, it can move from the any other person. What I want, 10,000 rupees. It may be given by promising or some other person. Yes sir, no sir? Bolo, everyone. Consideration need not move from promising itself. It may move from promising or any third party also. So there was a famous case la beta, as we discussed already, Chinnaya versus Ramaya. Chinnaya versus, so there was a case la, there was a good father, there was a good mother, there was a bad daughter. So before death, father said to daughter, I will transfer my whole property to you, Bangla. But every month you have to pay 10,000 rupees to your mother. Then there was a two agreements. Daughter said yes, there was agreement between the father and daughter. As per the agreement, father will transfer the property to daughter. Then daughter entering into agreement with the mother, mummy, every month I will give you 10,000 rupees. Then father transfer the property to daughter. Then papa mar gaya. Father deceased. Then daughter is giving some money to mother, few days, 3 months. Subsequently, daughter is thinking, every month how much I am giving to mummy? 10,000. What is giving me back? Nothing. No consideration, no contract. Then she stopped giving the money to daughter. Daughter, Ushar. Mother, Dedushar. Then mother said, Betty, every month you are giving me 10,000 rupees. I am not giving you anything. But something came from the father. For you, consideration is not moving from me. It is already moved from your father. Then beta, yes sir, no sir? Clear? Actual real facts, two brothers will be there, A and B, and A son X, B son Z. Why? Yes sir, no sir? So A said to his son, I will transfer my whole property to you. I will transfer the whole property, but every month you have to pay 10,000 rupees to my brother, to your uncle. After death of this A son stopped giving money to B, his uncle. B is asking, why you are not giving money? Then X said, every month I am giving you 10k. What are you giving me back? Nothing. But B said, yes, I am not giving you anything. Something came from your father. Then real facts. So first one, it may move from first heading. So it must be given the desire of the promiser, and it may be given from the promisee or any other person. Then next, it may be past, present, or the future. Consideration can be already happened, it may be happening, it may happen in the future. But as per English laws, it must be only present and future, but not a past consideration. As per Indian Contract Act, it can be past, present, future. As per English Contract Act, it can be present or future, but not a past. Then next, it must have some value. How much value? Can I sell my bench card to Manoj for 1 rupee? Yes sir, no sir? I can. So, but the consent is free consent. Consideration need not be equal, need not be adequate. It can be grossly inadequate also, but consent given must be free consent. So what I am giving to Manoj? Bench card. What he is giving me? 10 rupees or 1 rupee. Valid? Valid, because mera car, mera marzi. I can sell my car at any price. Then consideration, bolo everyone, consideration need not be adequate. It can be grossly inadequate. Also, selling the Jaguar car for 10 rupees is perfectly valid if the consent is free consent. Next, it must be real but not illusionary. Consideration must be real but not be illusionary or imaginary. It must be something possible to perform, something possible to perform. If it is impossible to perform, it cannot. For example, so I'm performing puja. One, क्या बोलते उसको, हवन, हवन, यज्ञम. Yes sir, no sir. What is the consideration? So you are going to get the, if that you're going to get the grandfather's life again. Is it possible to give the life to deceased person? Vaishnavi, Priya beta, busy unnava? Busy, huh? Good girl. Yes sir, no sir. Consideration, everyone. Consideration must be something possible to perform. If it is imaginary, illusionary, impossible to perform, it cannot become valid contract. It must be something more than the promise's existing obligation. So I said to Manoj, if you give me 10,000 rupees, I will teach you CA enter law. 10k. Yes sir, no sir. He said okay. Class has started. Subsequently, I said, if you give me 2,000 rupees extra, I will teach you nice. I will teach nicely. Can I say like that? No. Along with law, if I'm teaching auditing, can I ask extra? Yes. Consideration must be something more than promisers existing obligation. In this example, when he is ready to pay 10k, there is an existing obligation on my part to teach law nicely only. Then there was a case like Ramachandra Chintamani versus Kaluraju. In this case, one advocate said to his client, so actually he advocate agreed with the client for 10k to argue on his behalf in the court of law. Subsequently, advocate was asking extra money to argue better way. So client said, oh yes, I will ready to pay extra 2k also better. Subsequently, they won the case and advocate is asking for 2k extra. Client is not giving 2k extra. Then advocate filed a case. Will advocate win the case? No, because when is agreed for 10k, there is an existing obligation on part of the advocate to argue in such a way that his client has to win the case. Then it must be lawful. Consideration should not be unlawful, illegal, opposite to public policy. So I said to Manoj, I will give you 1 lakh rupees if you kill the Shashi Babu. Which Babu? Shashi Babu. What is consideration? Murder. Is it legal? No. So, one second, beta. Essentials of the valid consideration. First one, it must be given at the desire of the promisor. It may be given from the promisee or any other person. I kept so many stars also, Chinnaya versus Ramaya. And it may be past, present, or the future. It must have some value, need not be adequate value, and it must be real but not imaginary. It must be something more than the promiser's existing obligation. Yes sir, no sir. Next, it must be lawful, should not be opposite to public policy. Then there is a concept called as the stranger to contract. Stranger to contract, stranger to consideration. Stranger to contract को बोलते हैं privity of contract. Privity means private. In Latin, privity means private. So I entered into agreement with Manoj for sale of my car for 10 lakhs. It's a private agreement between Manoj and SG only. Third party is not supposed to interfere into agreement between me and Manoj. Then privity of contract means every contract is a private agreement between the parties to contract only. Third party should not intervene. Third party cannot sue. So because in a case beta Dunlop Pneumatic Tire Company Limited, Selfridge Company Limited. So if you remember the facts of this case law, so there was a manufacturer, there was a wholesaler, there was a retailer, there was a customer. There was a agreement between the wholesaler and the retailer. As per the agreement between the wholesaler and retailer, retailer has to sell the tire at MRP list price. If wholesaler selling the tire less than the MRP, he has to pay 1,000 rupees per tire sold as a damage to wholesaler. But retailer is selling the tires to customer less than the list price. Then who can sue? Wholesaler. But who filed the case? Manufacturer. Can he sue? He is a third party. He is a stranger. The contract was there between the wholesaler and retailer. Manufacturer is a stranger to contract. He cannot sue. Cannot bolo. Stranger to contract cannot sue. Only parties to contract can sue each other. For example, Manoj entered into agreement with Ishwar for sale of his car. Manoj gave the car to Ishwar, but Ishwar is not giving the money to Manoj. Manoj don't know how to file a case. Then Shashibabu came. Shashibabu said, I want to sue you. Can he sue? No, because he's a stranger. So Manoj can sue the Ishwar. Ishwar can sue the Manoj. A stranger cannot sue. Then see, now tell me. ये देखो बेटा, इसको बोलते हैं stranger to contract cannot sue. See, in the same example, Manoj selling the car to Ishwar. Ishwar said, I am purchasing this car to give as a gift to my cousin Aditya. Yes or no, sir? Done na beta. So Ishwar said to Manoj, I will give you 10 lakhs. I'll give you 10 lakhs. And you have to deliver the car to Aditya because he's my cousin. I want to give it as a birthday gift. So Ishwar gave the money. Ishwar gave the 10 lakhs. But Manoj not giving the car to Ishwar, not giving the car to Aditya. Can Aditya sue the Manoj? He's a stranger to contract only, but he's a stranger to consideration because the contract is entered for the benefit of the third party. Stranger to, well, everyone. Stranger to contract means a third party for whose benefit contract is entered. If Manoj, Ishwar entering contract for their mutual benefit, Aditya is a stranger. If Manoj, Ishwar entering into agreement for benefit of Aditya, Aditya is said to be stranger to contract and he can sue. If two parties are entering into contract for their own benefits, third party cannot sue. If two parties are entering into a contract for the benefit of the third party, then third party can sue. Said to be stranger to consideration. Actually, here Ishwar is giving 10 lakhs rupees to Manoj. Manoj is not giving anything to Ishwar. Manoj is giving something to Aditya. Consideration is moving to Aditya. Clear? Stranger to contract cannot sue. Stranger to consideration can sue. So give me some examples, sir. So when stranger to consideration can sue, he is given the 5 examples in ICA. One is the trust, other one is the family settlement, next one assignment, next principal and agent, last one is the holder in due course. First one is the trust beta. So we have seen a case beta, Amir Ullah versus central government. Amir Ullah versus central government. So Manoj entered into agreement with the post office. Manoj said to post office, I will give you 100 rupees, but you should deliver this post to my cousin Aditya. Yes or no, sir? So Manoj is giving the 100 rupees to post office and also that parcel to post office. The contract is between the Manoj and the post office. But post office was unable to deliver the package to Aditya. Then Aditya said, I want to sue the post office. Then post office said, post office is central government. Aditya is Amirullah. Sir, no, sir. Post office said, the contract is between me and Manoj. I can sue Manoj. Manoj can sue me, we each other. But you are a stranger. You can't sue. Then beta, but to code held that Manoj and post office is entering into agreement for benefit of the Aditya. Even Aditya is a stranger to contract, but is a stranger to consideration because you people entering into agreement for the benefit of the Aditya. So here Aditya is the beneficiary, post office is the trustee. Here third party can sue. Then family settlements. Which settlement beta? So there was a case beta Rukmini Bai versus Govinda. In this case, what was happened? There was agreement between the grandfather and father. GF. Grandfather and father. So grandfather said to father, "Arey, you keep the money aside for the daughter's marriage." Which marriage? Daughter's marriage. Beti ka shadi ka dabba. We discussed. Yes sir, no sir. There was HUF. In this HUF, this grandfather is having the so many sons. Each father is having the daughter. To celebrate their marriage, they're keeping the money aside. Then beta. So the agreement was between the grandfather and father. Subsequently, there is a partition of the HUF. At the time of partition of HUF, they want to take the money from the this dabba which was kept aside for the marriage expense of the daughter. Then beta. Then daughter said, "Hey, grandfather and father, if you take the money from that betika shadika dabba, I will sue you people." Then grandfather said, "How?" So the agreement is between me and your father. I can sue your father can sue me. But daughter said, grandfather and father, grandfather and father entered into agreement for the marriage expense of the daughter. You two people entering into agreement for my benefit. Being a daughter, I have a right to maintain the case because I'm a stranger to consideration. Then next, assignment and acknowledgement. Assignment means transferring the rights and duties to third party. So, for example, Manoj is staying in the Hyderabad. He has to give 1 lakh rupees to Ishwar staying in the Vizag. So Manoj has to go to Vizag to give the 1 lakh rupees to Ishwar. Ishwar has to give 1 lakh rupees to Aditya who is staying in the Hyderabad. So Ishwar has to come to Hyderabad. To avoid all this traveling and all, Ishwar made a call to Manoj, give the money to Aditya. Ishwar made a call to Aditya, said, take the money from the Aditya. Take the money from the Manoj. Then Aditya went to Manoj, asking the money, but Manoj is not giving the money to Aditya. Aditya said, I will sue you. Then Manoj said, how? There is an agreement between me and Ishwar. I can sue Ishwar, Ishwar can sue me. You are a stranger, you can't maintain. But Aditya said, you two people entering into agreement for benefit of me only. I am a stranger to consideration, but stranger to contract. I can maintain the suit. Then you're able to understand. So we are revising the nearly 3 to 4 hours lecture in the maximum 15-20 minutes. This is the power of the revision. Next concept, principal and agent. So SG is the owner of the shop, SG Kirana and General Store. I am the principal. In my shop, Ishwar is my agent, my employee. From the shop, and this guy Shashi is the customer. Shashi is the customer. Is purchasing the goods on credit basis. Who sold the goods? Agent. To whom? Customer. But customer is not giving the money. Then I said I will file a case on the customer. Customer said there was agreement between the me and Ishwar. I can sue Ishwar. Ishwar can sue me. You are a stranger. Then I said, my dear customer, my agent is entering into agreement with you for my benefit only. You people are entering into contract for my benefit. I have a right to maintain the suit. Then able to understand us. Last one. Next one. Holder in due course was a negotiable instrument. For example, Kattappa has to give 1 lakh rupees to Bahubali. Bahubali drawn the bills of exchange on the Kattappa. Kattappa accepted. He said, yes, sir. He gave it back to Bahubali. Bahubali gave it to Devasena. Devasena gave it to Avantika. Avantika gave it to Shivagami. Shivagami gave it to Bijjala Deva. Bijjala Deva gave it to Ballal Deva. Ballal Deva gave it to Salman Khan. Salman Khan gave it to Shah Rukh Khan. Shah Rukh Khan gave it to Ram Gopal Verma. Ram Gopal Verma went to Kattappa, is asking the money. Kattappa said, मैं नहीं देता, क्या करता कर लो. Then RGB said, I will sue you. Kattappa said, how I can sue Bahubali? Bahubali can sue me. But RGB said, hey, you people entering into agreement for my benefit only. I'm a stranger to contract, but stranger to consideration. I can maintain the suit. Done. So, trust. Central government versus Amirullah. And we have discussed one more case also, Khaja Muhammad versus Usani Begum. That love story. Next, family settlement. Rukmineba versus Govind, we have discussed. Acknowledgement assignment, we have discussed. Principal and agent, holder in due course. And in case of the covenant sending with the land, covenants means conditions, restrictions. When you are purchasing the property, see, there was agreement between the Ishwar and the GHMC, Greater Hyderabad Municipal Corporation, municipality. So GHMC said, I will give the permission to construct the building in Hyderabad, but every year you have to pay 10,000 rupees. For last 2 years, there was a pending arrears of the municipal taxes. Then Ishwar sold the same building to whom? Beta Shashi. Yes, sir, no, sir. Then GHMC filed a case on the Shashi to recover the money. Can? Yes. Because when you people are entering into agreement, I am also beneficiary in that agreement. Then beta clear. Next concept is the no consideration, no contract. Contract without consideration is void agreement. Void agreement, because as per section 10 of the Indian Contract Act, valid consideration, lawful consideration is one of the essential element. If there is no consideration, it will not mature into valid contract, that will die as a void ab initio agreement itself. No consideration, no contract. It is also known as the nudum pactum. Nudum pactum means no consideration, no contract. And there was a Latin quotation is there, ex nudo pacto non oritus actio, which means no action will arise. Which means no action will arise without a consideration. No consideration, no contract. Then, so we have discussed two cases: Abdul Aziz versus Mazum Ali, Kedarnath versus Gori Muhammad. So what was happened in this two cases? Abdul Aziz versus Mazum Ali. There was an old masjid where there is no proper facilities, no ventilation, no color, no water, no mic. One Ishwar said to Maulana Sahib, who's head of the masjid, who makes the prayer, Maulana Sahib, go for renovation. If you incur any expenditure, I will try to reimburse you. Who said Ishwar to Maulana Sahib? Then Maulana Sahib came to SG Hardware. He was taking the quotation. The total worth of the renovation will be, including labor and material, 50,000 rupees. Then subsequently, this Maulana Sahib came to Ishwar, asking the Ishwar, where is the, if you give me 50,000 rupees, I will go for renovation. Then Ishwar said, Maulana Sahib, I will give you 50k. What will you give me back? Nothing. Then Maulana Sahib filed a case. You made a promise, bolke. Then court said that it is a gratuitous promise. Which promise? So even Ishwar is giving the 50k to masjid. He is not getting anything from the masjid. So no consideration is there, no contract. It is a word ab initio agreement. Who lost the case? Masjid. Then Maulana Sahib lost the case. There was another case, Gori Muhammad versus Kedarnath. In that case, so there was a Maulana. Who is, what is this J? Who is J? In our class? John. John is the Maulana Sahib. John is the Maulana Sahib. So, Kedarnath said to Maulana Sahib, go for renovation of the masjid. If you incur any expenditure, I am ready to reimburse. Based on the wording of the Kedarnath, then Maulana Sahib purchased cement, cable, lighting, and that even mic is working. So he was spending 58,000 on credit basis from the SG Hardware shop. Subsequently, Kedarnath came to city, and Kedarnath said, I will give 58k to masjid. What will you give me back? Nothing. No consideration, no contract. And Kedarnath fails to pay the money to Maulana Sahib. Maulana Sahib filed a case on the Kedarnath. Court held that who will win the case, beta? Maulana Sahib. Because if you break the promise, no beta. So this Maulana Sahib has to pay the money to SG Hardware. Then because of his fault, he should not incur any loss. In the previous case, he didn't incur expenditure. Here he was incurred the expenditure. Yes sir, no sir. So court held that Kedarnath has to compensate the Maulana Sahib, even it is a gratuitous promise, because based on the gratuitous promise, Maulana Sahib already incurred the expenditure. Light is purchased, paint is painted already, done. So generally no consideration, no contract. It is having so many exceptions also, but in these exceptional cases, even without consideration, there is a valid contract is there. We have seen a beautiful example also. Agreements made on account of natural love and affection is enforceable if it is in writing, if it is registered, if there is a natural love and affection, if the party is standing in the near relationship. But remember, just because of near relationship, there may not be natural love. So one wife and husband is there, they're fighting with each other, juttu juttu pakadke, they're fighting with each other. Then they applied for the maintenance. Court held that case is not maintainable because agreement is there, it is in writing, it is registered. There is a relationship is there, but there is no love because they're fighting with each other, wife and husband. Yes or no? Kavyamma? What happened, Kavyamma? Next, promise to compensate past voluntary activity. Generally, for voluntary activities, consideration is not required. If you're making a promise to compensate past voluntary activity, it is enforceable. We have discussed है ना बेटा. So मनोज went to honeymoon, इसका घर जल गया. ये क्या है बेटा? इसका बिल्डिंग है बेटा. क्या हो गया बेटा? विला जल गया. और बाजू वाला अंकल ईश्वर was saving the property. Voluntarily he is saving the property. Then Manoj promised to compensate that voluntary activity. So can Ishwar recover the money from the Manoj? Yes, because even Ishwar is doing the activity voluntarily, you made a promise to compensate that voluntary activity. Next, promise to pay the time bar debt. Generally, the life of the debt is only 3 years as per the Indian Limitation Act. Which act? Indian Limitation Act. After expiry of the 3 years, we cannot recover the debt lawfully or legally. Then it will become zero. But if you make a promise, it again that expired date will get the life for next 3 years. Then if debtor makes a promise to repay expired debt, time bar debt, again such debt will get the life for 3 years. Even without consideration, it is enforceable. Next, gift beta. Next one is the gift. Gift does not require any consideration. If free में दिए तो बोलते हैं उसको gift. And agency two types, gratuitous and non-gratuitous. Gratuitous means free without expectation anything. So gratuitous agency does not require any consideration. Bailment is two types, gratuitous, non-gratuitous. Gratuitous bailment does not require any consideration. Last one is the charity. Charity means free of cost. So charity does not require any consideration. So we have done with the revision of consideration. In the next class, we'll do the scanner. मित्रों मेरे प्यारे देशवासियों. Done. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care.